Hi, and welcome to another edition of the Trustcast Show. And we're really lucky to have on with us today John Surma, who has a really interesting story. John, welcome to the show.
Well, thank you, Zane. I appreciate you the invite, and I'm looking forward to having this conversation with you.
So, John has personally investigated over 400 workplace deaths, refinery explosions, pipeline blasts, construction collapses, and it's often the first call a company makes on the worst day it has ever had. So, John, walk me through that first phone call. What does the person on the other end of the line usually sound like?
It's a combination of frantic, emotional, angry, and hurt, all kind of wrapped up in one thing. I mean, imagine you are responsible for a facility or you're responsible for an organization and somebody died. I remember sitting in my car in the Corpus Christi area in the early 2000s with the president of an organization that had lost an employee as a result of one of these industrial deaths. And in this very kind of gut wrenching, heartfelt way, he said, John, somebody died on my watch and this can never happen again. And I mean, it was with all of the emotion and sincerity of somebody having lost a child or parent. These folks are invested in their organizations, they're invested in their people, and this is truly one of the worst days they personally will ever experience in their lives. And certainly for the organization, it's one of the worst days they've ever experienced, if not the worst.
So, immediately springs to mind. I have this whole set of questions all lined up, but as we get started, I'm going to probably diverge quite a bit. Immediately spins to mind, how did you end up, or so how do companies know to call you?
So word spreads fast about who is capable, qualified, competent to deal with this stuff. The first thing started off as referrals from other clients, or actually other attorneys' clients, and then kind of as the ball got rolling, somebody's had somebody die, they know somebody else, and that person has somebody die. So, who did you guys use when somebody died, or who did you guys use when you had this problem at your plant, or when OSHA showed up, or whatever the case might be? And it's really a word of mouth process. And once you do well in that work, because there's not a lot of people that do it, and if you're accessible, you're going to get the work.
So, you spent 9 years as a trial lawyer in Beaumont before you became the OSHA guy. What pulled you specifically into workplace safety?
Well, the 9 years in Beaumont were it started off about 10% workplace safety and ended up basically 100% workplace safety. It really started when I was in Wisconsin. I was the only single person without children or any other commitments. And so when something bad happened, pick up the phone and call John. But this was back in the day when we still had landlines as opposed to cell lines, and they could get you anywhere you were anytime they wanted to. Now you just can't put your phone down, and people will call you all hour of day, weekends, holidays, whatever. If they have a problem, they're going to call you.
So how does that emotionally work when you're involved in these things? And you on a semi-regular basis. I mean, it's not every day, but emotionally, you've got to get drawn into the whole situation.
Yeah, I mean, we're sitting with people who are emotionally distraught. You feel it. It's challenging and it's taxing, but at the same time, I think from the standpoint of a lot of lawyers, there's a lack of satisfaction because they don't see kind of at the end of the day or the end of the week, a widget or a pile of widgets should be created by their work. I can see when I'm dealing with folks that are in these troubled times and kind of explaining how things go and helping them through those troubled times, you can see as you progress through the process, the relief that they start to experience. And that's very gratifying and satisfying. But it's challenging. You end up, I mean, there's a level of, survivor's guilt or whatever you end up feeling kind of as a result of, not being the person that's lost somebody, but you're around so much loss. You know, like when I've had deaths in my personal life, I don't grieve like a normal person because I just don't have a lot of the feelings that normal people have because I've experienced death, 500 times as a result of other people experiencing death.
So, so the other question is, so if I'm a CEO of a company and somebody dies at a plant on my watch, and there's so much guilt associated with it, even if you're not the one who's responsible, you still have all this guilt. How do you counsel the heads of these company to, you're there to protect their interest and their stockholders' interest, but you're not, without some human underlying emotion there. So how do you counsel these people? Don't react. Don't get emotionally drawn in this. We have to be somewhat analytical, even though it feels harsh. We have, multiple things we have to do. Take care of our employees, sure, but we also have our stockholders and the owners of the companies that we have to be thoughtful of.
Yeah,
So,
and it's a challenge for a lot of CEOs because a lot of CEOs are expected to have kind of the stiff upper lip regardless of what the circumstances are. And a lot of times you walk into their offices or in these facilities and they're there and you can see the emotion on their face. One of the things, we have a conversation about this isn't about you. This is about, this incident and we have a long path ahead of us. And I'm a huge advocate for getting counseling, whether it's grief support counseling or disaster support counseling, but getting counselors involved for even the highest levels of management because they are experiencing grief. And when we get them through even a single session of counseling, it tends to really relieve them of a lot of the feelings that they had leading up to that counseling session.
So, if someone just died at my work site, what do I need to do in the first hour before I've even called a lawyer?
First on our range, you make sure that people are taken care of. So you call 911 and police and EMS are going to respond. And typically they'll be there within minutes. You got a law enforcement investigation taking place from the get go, and you've got to preserve the scene. So I mean, you have to tell your people, don't do anything to damage anything, and then you need to document or you need to have documented everything that's taking place. So people taking photographs, people taking videos, but preserving the conditions on the scene so that later on, after you call the lawyers, after the regulators come out, not to be crass, but after the blood dries, that we have a record of what's happened out there. The second thing is get your people kind of out of there. Typically, it's best to kind of get them huddled up in a conference room or whatever and have people talking to them and just kind of, I don't want to say distracting them, but not talking about the accident itself, just talking about kind of what the process is going to be and the forward process is going to be so that they kind of understand what's going on. And quite frankly, before you call lawyers, I think it's good to get grief counselors called in because I think the value of grief counselors in this day and age is so valuable. I think we underestimate it in a lot of instances.
So how fast does OSHA usually show up after a fatality?
It depends upon how close you are to the OSHA office, and it depends upon the day of the week. It also depends upon kind of what's going on at OSHA. So last year I had a fatality. I got called by the client Sunday afternoon. We reported it to OSHA. Employers have an obligation in federal OSHA states to report within 8 hours of the death. A few hours later, I get a call from an assistant area director who says somebody is going to be out tomorrow. They showed up the next day. They took some pictures and left and didn't show back up again for about 6 weeks. And when I say took some pictures, not a lot of pictures, but typically speaking, it's going to be next day. If it's close to an area office and it's kind of a higher profile situation, they'll usually be out there that day if it's during the work week. On weekends, a lot of times it's hard for them to get folks out until the following business day.
So do I have to let OSHA inspector interviews take place with my employees without me in the room or without representation in the room? Is that standard?
So it's standard, but there's a little bit of a nuance to that. The employee can insist on having counsel present, whether it's counsel of their own choosing or, somebody that the employer's hired. They can also, I mean, quite frankly, if an employee wants to have their brother, their mother, a coworker, whatever, somebody there just kind of support, they can ask that that support person be present. And typically OSHA, particularly with just support people, will accommodate them. I mean, they will, because they don't want to delay the process, they will kind of, do we really need to have somebody out here? But if the employee insists on it, yeah, they'll let them do that. But generally speaking, OSHA's position is that they have the right to interview employees individually. My argument back is that the way the OSHA is structured, it's the employee's right to the interview with OSHA, not the other way around. And so whatever the employee wants, that's what they get.
So, what's the single biggest mistake a company makes in the first 24 hours after an incident?
Single biggest mistake. Now that, Zane, that's a tough one, because there are really three huge mistakes that I see people make. Mistake number one is they don't preserve the scene. And as a result of not preserving the scene, evidence is lost and we'll never recover it and we'll never be able to answer what happens. Issue number two is a lot of employers are unaware of their obligation to get any sort of outside authority involved. And so they try to handle things kind of on their own without contacting OSHA, without contacting law enforcement, without contacting anybody. And typically that sets off a really kind of bad chain of events. The last thing is the hastily assembled press release or statement relative to the incident that kind of sets a tone that is different than the tone the employer really would like to set. And just it's not professionally assembled. Maybe they're making admissions that they shouldn't be making. Maybe they're making promises that they're never going to be able to deliver on. So those three are kind of the big three that I see in the first 24 hours.
So, how do you handle that? Because the media can be pretty brutal on the company, regardless of who's at fault. And the company, from a mitigation standpoint, the way they want to preserve their brand and what they stand for, they want to get out in front of it as quickly as possible. So, how do you advise companies with regards to doing those two things? Because you talked about getting together with the press and giving some sort of release, and oftentimes they make that's a mistake. How do you balance that, or what would you advise somebody?
Well, I mean, and I think a lot of companies don't think they have a need for a relationship with a crisis management firm. And I think having a relationship with a crisis management firm or with lawyers that have relationships with crisis management firms and getting them involved with your business prior to anything going bad is step number one. Step number two is if you don't have one and you have something happen, getting a crisis management firm involved early on. Those folks typically have relationships with local media and have the ability to kind of influence the messaging outside of drafting statements to the media. And so, the crisis management firm and the work that they can do really is crucial to the process of kind of managing the media and managing any misstatements or poor statements that a company has put together without the assistance of one of those firms.
So, is there something that I can say or might say in an interview with either the authorities or in the media that will come back to, hurt me in a serious way later? Maybe you can give me an example, if you have one that off the top of your head, where somebody did something, historical, obviously not going on, because I don't want you to give away any, client confidence, where
Sure.
somebody did something, they stepped in it, so to speak.
Yeah. So this is an incident from about 15 years ago where client had a process that was unstable. And they were having some issues with the process, and the issues with the process ultimately caused an incident where three people ended up getting burnt severely. I mean, just horribly burnt. They all survived, but with burns over 75, 80% of their body. And one guy had like third-degree burns over 60% of his body. It was bad. And, in the first statement to the press, they were talking about they were having issues with the process. And, as a result of the issues with the process, they had, unfortunately, a small fire that progressed, et cetera, et cetera. And it literally provided the roadmap for the plaintiff's attorneys that were representing the injured. It was actually contractors, it wasn't employees, but it was, representing these contractors, and they just walked through the case in their initial statement to the press and basically just gave them the roadmap to how to make the case against the employer. And it wasn't as clear cut as the statements made it out to be, but because of the nature of the statements, because of the content of the statements, they lived with that for about 2.5 years until they ultimately resolved those personal injury cases.
So, what's the difference between a serious, a willful, and a criminal case? And how do I know which one I'm actually in?
You never actually know if you're in a criminal case until you find out that you're in a criminal case. One of the things that I tell employers all the time is, if you have a death or serious injuries in your case, there was a criminal investigation that is taking place, even if it's not a particularly active criminal investigation on the part of local law enforcement. So it's either going to be the county or the state is going to be looking at those cases from the standpoint of, is there some sort of criminal neglect? Is there some sort of criminal intent, what have you, that resulted in this incident? From OSHA perspective, a serious involves a lesser level of defiance of the standards than a willful involves. So a willful is you violated the standards and you knew or essentially knew that your violation of the standard was going to result in serious bodily injury or death. Whereas a serious is, not so much on the knowing part about the standard, not so much on the intent part in terms of the injury, but it has a high degree of probability of causing serious injury. Criminal cases are limited in the OSHA world. Generally speaking, if you lie to OSHA, if you destroy evidence, or if you obstruct the investigation, and all three of those are really kind of intermingled with each other. I mean, lying to OSHA is obstructing, damaging evidence is obstructing, but it's all kind of in that arena. If you don't do one of those things, unless the level of intent or lack of care is just through the charts, OSHA isn't going to pursue a criminal referral. They'll make the referral to the U.S. Attorney's Office, the E&R division, and E&R will look at the case. But unless you just go absolutely crazy with just complete and total disregard, where you essentially know you're putting people in harm's way, there's not going to be a criminal case. Or if you don't lie to them, if you don't damage evidence, if you don't destroy evidence, or if you don't obstruct the investigation, there's not going to be a criminal referral. I've been involved in 2 cases where criminal referrals, in one case it happened, in one case it could have happened, but the compliance officer kind of gave us a little heads up, and so we were able to kind of get the client on the right path. It's got to be really, really, really egregious behavior to get criminal.
Okay, so that was interesting because I had a follow-up question about I talk to criminal attorneys and they always talk about their clients about just shut up. You can't do that in this instance, can you?
Yes and no. I mean, you can always invoke your Fifth Amendment right against self-incrimination. And you have the right to essentially say nothing. Just a little aside, I used to work with a married couple. They were both lawyers, and he and I were very good friends. She and I were friends, and I used to get her all steamed up at him or steamed up at me, one of the two. And they had about an hour ride home, and she would just be chewing on his ear the whole time. And his response to it was, "You can't make me talk." It's kind of the same thing here. You can't make somebody talk. You can invoke your Fifth Amendment right against self-incrimination, but typically speaking, if you're not talking to OSHA, you're viewed as obstructing the investigation. So you've got to talk with them unless you're invoking your Fifth Amendment right against self-incrimination, and you have to do that sparingly, because doing it excessively is not helpful either.
So it's kind of a catch 22 in these particular situations. You're damned if you do, and you're damned if you don't. Unlike a regular criminal investigation, there is a certain risk, but you say it's pretty rare.
Yeah, it's. I mean, it has to be a really extreme case. If you look at the criminal cases that OSHA has made, and these are cases where typically people have been cited by OSHA a bunch of times before. It's really, really, really bad conduct. The conditions in the workplace are just atrocious, and these folks end up being criminally cited. Now there are some kind of the big corporate type cases that have been made where it's just kind of a series of unfortunate events have led to a situation where to get the point across, OSHA pursues a criminal investigation, but it's rare.
So when OSHA asks for safety records, what are they really searching for?
So they're typically looking for, well, safety records are kind of broken down into two things, or the way I look at them are broken down into two things. One is your OSHA forms, so your 300s, your 300As, and your 301s. The 301s are the records that are in more depth about the individual injuries. The 300 is the log of individual injuries, and the 300A is the annual summary. And they're looking at that, really to see kind of what the trends are and truly are the records complete. The other side of the safety records are things like training records, programs, policies, procedures, etc. And they're looking, typically speaking, there that do you have the records that would support a unpreventable employee misconduct defense? So in other words, do you have policies relating to a particular issue? Do you train on the particular issue? Do you discipline on the particular issue? And those are typically what they're looking for. So, if you have somebody who fell from height, as a for instance, they're going to typically ask you about records that relate to fall protection training, working at height training, things like that. Then, do you have programs in each of those areas? And if you do, then have you gone out and exercised discipline? And if you've done all three of those things, if you have all three of those things, then typically they think long and hard about issuing citations for a violation of that particular standard.
So if I do get cited, is fighting that citation realistic, or are we just negotiating the penalty?
It's funny that you mentioned that, saying just yesterday I posted on LinkedIn about that. Or actually, I was going to write a post about that, but then I got sidetracked and wrote about something else. Yeah, I negotiate about everything. So, it's the citation itself. Should this citation be issued? Should it not be issued? The description, what's referred to as the AVD, the alleged violation description. So you'll have the standard cited when you're looking at your citation. There'll be a reference to a citation, or a reference to a standard, excuse me, and then there'll be an allegation. So the alleged violation description is, on June 22, 2026, employer failed to do XYZ and this resulted in injury, or whatever the description is. Sometimes the language in the description is important, whether it's for the personal injury litigation or whether it's to prevent things like that from being cited again. We'll contest or negotiate the classification. So other than serious, willful, repeat, etc. The amount of the penalty, abatement, the need for abatement, the time for abatement, and then of course, obviously the penalty, whether we can have a payment plan, how much the payment plan will require we pay per month, how long the payment plan will be. Yeah, you can negotiate every aspect of that.
So you've represented everyone from refiners to nuclear energy clients. Does the playbook change by industry, or is it, each situation different?
So certainly the language of the industry changes when you're going from industry sector to industry sector. So, nuclear is kind of its own realm, and a lot of nuclear safety issues are handled by the Nuclear Regulatory Commission. But, from the standpoint of, like you take refining to chemical plants, those are kind of sister industries. So the language is kind of the same. But if you get into things like, green energy, so wind or solar, or if you get into, home building or what have you, you're talking about completely different languages. And so a lot of times the language changes pretty dramatically. But generally speaking, the playbook is more or less the same, recognizing kind of the limitations. Like if you're talking about a greenfield residential construction project, you don't worry about people walking around on the job site except for kind of the major, there's a big excavation there. We can't get on the edge of that excavation. Whereas if you go into a chemical plant or a refinery, there's all kind of things in those facilities that are hot, that are under pressure, that randomly emit steam or, contain, very, very deadly chemical substances. And so, like handling the walkthrough in those facilities is completely different than handling the walkthrough in a home construction site. But generally speaking, the big parts, the big overviews in the playbook are the same.
So you also serve as general counsel for some of your clients. How does that change how a case gets handled compared to hiring a pure litigator?
Sure. So when you have the general counsel hat on, you understand kind of that business's unique sensitivity. I mean, every business I've ever worked with has unique sensitivities, unique concerns. Their ethical codes may more or less look the same, but kind of how they prioritize, A to Z, ethical responsibilities, et cetera, those are different. When you're functioning as a general counsel and kind of what their priorities are, and kind of what the business situation is, and where the business sits financially, it takes on a whole different meaning to me, in as much as it's much more personal, and because the relationship is different than somebody I've never dealt with before, you also feel their pain a lot more directly, because it's no longer somebody you just met as a result of something horrible happening. It's somebody you've had a relationship with for a decade or two. And you can see the art in their eyes, and you can hear it in their voice. And it's a completely ratcheted up level of kind of emotional or emotionality.
I can see that. Become more personal. So I have some specific questions about cases you handled. You have 6 heat-related citations thrown out after a fatality at a tire manufacturing plant. Tell me the specifics on that. How did that happen?
So the client was the security company that basically they guarded the gates, and then they did kind of the perimeter walks through a facility, much like I'm sure you're envisioning in your mind's eye. They signed off on confined space permits, and OSHA basically construed the fact that they signed off on these confined space entry permits as evidence that they were the controlling employer. And basically, we took OSHA to task on this with 2 pathways. One pathway was we hired somebody who's a renowned expert on these heat cases, and he established that the heat case that OSHA was making, it was not a dangerous environment, especially under the circumstances as described in all of the files that OSHA produced. And then number 2, we were challenging with a motion for summary judgment the application of the multi-employer citation policy, and saying that multi-employer citation policy didn't apply here. I'll be honest with you, the expressions "I'd rather be lucky than good," I think applied in this case. We ended up with a lawyer representing OSHA that didn't seem to want to handle the case or the challenge we were making, and I think we kind of bored him to death, or drilled him to death, or scared him to death of, we're going to have to deal with all these motions. And he ultimately just agreed if we would stop doing this permit, signing off on these permits, they would vacate the citations.
So did that change any of the liability side of it, or once you're done with the company part, you're done with the situation?
Well, in that case, it did alter the liability part, and the client was able to avoid liability because, up until that point in time, the lawyers for the family were arguing that, well, you signed off on the permit, you must have responsibility for this. And then when OSHA withdrew the citations, it became very difficult for them to maintain that argument, and they ultimately dismissed the case. So, I mean, it did have impact on that case. Normally, it doesn't have much of an impact, or the impact is less than the lawyers think it's going to have, but in this case, it was pretty big impact.
So there's a case where OSHA cited the wrong standard entirely after a fatal incident at a port. How did you catch that, and what ultimately happened?
So the ultimate disposition on that one was that OSHA vacated the citations in that case. There's two standards that relate to maritime work. So there's basically kind of a port side set of standards, and there's basically kind of a if you're on the ship set of standards. And they cited the on the ship set of standards when they should have cited the when you're on the port or dock side standards, 1915 versus 1917. And it was kind of a situation where when we got the citations, it was like, okay, I don't think they realized the mistake that they just made. And so we're just going to lay behind the log on this until we get with the lawyers, because we knew the aerial office would not understand and would not differentiate between the two. And so when we got we got into the contest and he got before the Solicitor Labor's office, we just had a conversation with them and said, look, they cited under 1915, they should have cited under 1917. You got, or vice versa. I don't remember which one it was. And it took them a little while, but they came back and said, you're right. And they're not going to take a case where they know that OSHA has screwed up. And there were some other issues. This is one that I've talked about a fair amount over time, Zane, where we had a compliance officer who was retiring about 3 weeks after the citations were issued, which I think helped our case. But it also didn't hurt our case that when he was coming into the port, rather than wait for port security, he bypassed port security, causing all kinds of alarms to go off and causing my client 12 levels of headache dealing with, Customs and Border Patrol, Homeland Security, the Coast Guard, et cetera, for this violation of port security measures. So there was a lot going on there that I think made it very easy for them when we gave them kind of a really legitimate reason why those citations can't move forward, to just vacate the citation. They didn't want to deal with the headache that what the compliance officer had done was going to create.
So this one's kind of interesting. You push back on the constitutionality of OSHA's in-house judges. What made you take on that fight? Because that seems like a pretty big fight.
I was saying, you're talking about my favorite thing right now. So with the Jarchese decision, and I don't know how familiar you are with that, but that was where Mr. Jarchese was being pursued by the Securities and Exchange Commission. And kind of, high level summary of that case for folks that aren't aware, the SEC has the same sort of structure relative to its quote unquote courts relating to SEC issued penalties. And so if they aren't going to pursue a criminal case, they can pursue one of these civil cases using this similar sort of SEC court setup. And Jarchese challenged that and said, look, I should have the right to a trial before a U.S. District Court judge and a jury. And the Supreme Court ultimately agreed with that. The in-house judicial body is the Occupational Safety and Health Review Commission. It's structured very similarly to the way the SEC adjudicates these cases when they do the civil adjudication. And at the end of the day, the Supreme Court has kind of moved things in a direction where these challenges are ripe. And thus far, we've had really good success with them, in as much as OSHA doesn't even want to get to the district court for a hearing on these things. They've just been withdrawing the citations because I think they're afraid that we're going to prevail. And if we prevail, unless Congress acts, OSHA is going to issue citations that it can't do anything with, it can't enforce. And so it's I've referred to it as kind of the easy button as relates to some of these OSHA cases. And it doesn't seem until we get into the wrong court, if we get into a court where OSHA thinks it's going to prevail, they might not be so inclined to dismiss the cases. But thus far, we've not ended up there. We're on our third, and we're going to be filing our fourth here soon.
That's very fascinating. I can see why that's one of your favorite topics. So is there a case where the facts look terrible for your client at first, but then you found a way out? It's something that you can think of off the top of your head?
Yeah, so we had a case where, well, let me back up. So there's two types of cases. So the one case is the case where you have terrible, terrible facts, but OSHA doesn't do anything. And you kind of sit there and like, hey, look, I'm not gonna look a gift horse in the mouth. Then you have the other cases where you kind of litigate them, and two cases in each side. So the one case was a case in a furniture warehouse where a guy was up about 45 feet in one of these high lift picker type forklifts, and for whatever reason he didn't tie off, and he was found several hours later at the bottom of his picker, deceased as a result of a head injury from the fall. There was plenty of reason for OSHA to issue citations, but the compliance officer and I, in the last case that we had together, went through a deposition where I made it very difficult for the compliance officer, and she did everything she could to find, though I thought we were going to get cited, she did everything she could to find reasons not to cite us. And so we got done with that investigation, no citations issued. And the client was like, yeah, you told us these three things could happen or should happen, and they didn't. Why did they not happen? Kind of, were you setting us up? And it's like, no, I think we got the right person. And she just wasn't willing to go through another deposition. And so she wasn't going to find citations. The other case was a case that involved a fall in a wind energy tower. So, everybody's familiar with the big three-bladed windmills. And so I was representing a company that did work with those, and somebody fell from that tower. And we had received citations for various fall protection items. And, we went into the informal conference, and I had zero expectation that OSHA was going to move, but the client had come up with some really brilliant ideas in terms of how to prevent this type of incident from ever happening again. We sat down, we had a wonderful explanation with OSHA. OSHA agreed with us, and they vacated all the citations. So, I mean, it doesn't always end up in a situation where, the employer ends up taking the lumps. I mean, sometimes we prevail, and actually more often than not, I think we do prevail. And then of course, if we go back to the prior question about the challenges to OSHRC, on behalf of two clients, we had the litigation going in OSHRC. We filed litigation in the U.S. District Courts. Before we got to the point of having to file the motion for summary judgment or the motion for injunctive relief, OSHA picked up the phone and said, would you dismiss that case if we agree to vacate the citations? And they vacated the citations in both cases. So there's been a number of cases where we've turned things around in a pretty big way for clients.
So John, here I have one of my notes was you recovered nearly $5 million for a client in a construction dispute. What was that case about?
Sure. So that was in a chemical plant. Everything, people don't realize how complicated chemical plants are and refineries are, and they don't realize kind of the efficiencies that they try to achieve. And so in the chemical plant, they try to recover all the heat that they possibly can to either reuse it for the process or to reuse it to create electricity. In this client's case, they were doing a little bit of both. Well, they brought in what's called an EPC firm, an engineering, procurement, and construction firm, to basically rebuild a boiler so that they would reduce the NOx, nitrogen oxides emissions coming out of that boiler. Basically, the client had spent about $1 million on this project, and the project didn't deliver the increased efficiencies and didn't deliver the emissions controls that it was supposed to deliver. And so the client asked me to sue the EPC firm as well as the manufacturer of the burner and the boiler that was supposed to deal with the emissions. And after a year and a half, 2 years of litigation, we ended up in a mediation, a very, very contentious mediation, but we were able to resolve it with a $5 million, it was $4,950,000 in settlement for the client, and the client obviously was ecstatic. It spent $1 million and recovered $5. They thought this was the greatest thing since sliced bread. But it was a hard fought battle, and it's with a guy that I'm still friendly with today on the other side. But it was kind of made a couple of really good choices along the way, and as a result of those really good choices, was able to net the client a wonderful outcome.
So, John, is there a myth about the just cooperate fully with OSHA that actually gets companies in trouble?
Yes, or I mean, look, I think I'm dealing with an inspection right now with a compliance officer that he and I, if it weren't for the fact that there were limits on his ability to like let me buy lunch, we would be best friends. And cooperating with folks and getting along with folks normally is appropriate, but it's like any government investigator, just go along and cooperate does not help you out. I do all kind of regulatory things, Zane, and whether it's state level licensing or state level regulators or federal level regulators, there's a level at which you want to cooperate. You don't want to make things that you have to do hard. Just provide them the information that they're entitled to have. But there are times when you have to draw lines in the sand and you have to say, no, this is it. The classic example in the OSHA context is something happens, somebody gets hurt. You have to call it into OSHA. OSHA comes in. They're allowed to look at the immediate circumstances and surroundings based on the fact that you reported that incident. They're not allowed to look at your entire facility as a result of that incident. And I don't let them look. I mean, you're going to look at the incident. You're going to look at what caused the incident. You're going to look at what's adjacent to the incident. You're not looking throughout the rest of my facility. And, sometimes people are very uncomfortable saying no to people. And sometimes no is the best answer you can possibly give. So, yeah, I mean, there's a huge myth there. And there's also this misconception that like, well, if we do this, if we say no here, or if we don't agree to this or whatever, then OSHA is going to come back and OSHA is going to cause a headache, or whatever regulator is going to come back and cause a headache. If OSHA were to investigate every single job site in this country at the rate they're doing it, it would take them about 250 years to investigate everybody. There's no way, they don't have the bandwidth to decide, saying you run a business, you told us no, we're going to come back every 6 months for the next 3 years, and we're going to find a reason to inspect it. They don't have the bandwidth. And so saying no, we say no all the time.
So I would think a lot of inspectors would push that. So how do you? So if you don't have the advice of counsel right there, how do you get the word out to someone? I guess it's if you're the GC, then you can advise them in advance. But if you're not the GC, you're called in afterwards. You just advise them going forward. This is just an observation. I was just thinking if a lot of inspectors, I think, would push that.
They do, and so newer inspectors in particular don't really kind of understand the boundaries of what their authority are, and so you end up with a lot of the newer inspectors kind of pushing those boundaries. But the folks that are there for like 5+ years, they've been around the block. They've been told no many times. They've been told no in a lot of instances in a very disrespectful and unprofessional way. And so when we're having a conversation, it's like, look, the thing that got you in the door here was this accident. You have probable cause to investigate this accident and nothing more. They're good with it. They don't push back on it. But sometimes, like you said, the clients don't get us involved immediately. They look a little bit further, and sometimes we have to essentially retroactively withdraw consent to the part where they went beyond the probable cause that they had. That can be a little bit of a challenge, but it works, and OSHA respects it, and particularly when it gets the solicitors of labor they understand what the law is, and they respect it.
So do you have to come in occasionally and clean up after another attorney that maybe, so they call the regular general counsel and say, we've had this death, we've had blah, 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 yeah, and we're in this situation. And the general counsel says, no, no problem. You don't need to call anybody else in. I can handle it, and they really don't have the expertise yet. Can you maybe speak to an example of where that happened?
Well, it's very adjacent to that. So this past year, a contact of mine on the Gulf Coast, a little bit east of here, picked up the phone and called me and said, "Hey, look, there's been a fatal incident." Our client, they were essentially the outside general counsel for this client. We think it's beyond our capability, and could you get involved? Yeah, happy to get involved. Got involved. Unfortunately, the walkthrough part of the inspection was complete. That it wasn't controlled the way it should have been controlled. It wasn't documented the way it should have been documented. We were handicapped a little bit as a result of this. But I mean, look, at the end of the day, you deal with the cards you're dealt, and you make the game you can make, and whatever hand you come up with, you come up with it. And we ended up with a good outcome for the client. But it does happen, and of course, because there's a long-standing relationship with that other lawyer, or the lawyer as the general counsel, we can't be critical of what they did, because then we're talking poorly about the client. So, it's just, we're gonna work with what we got, and we're gonna get you the best outcome we can get with what we've got.
So here's another perspective. So you write and speak constantly on workplace safety. What do you still find yourself getting wrong, or maybe really not getting wrong, but rethinking?
So the thing well, there's a few things that I'm kind of constantly rethinking. I constantly rethink how we produce information to OSHA or any other regulator, and whether we're producing information the most effective way we can produce it. So I'm not talking about the actual content, but should we highlight things to point out what they're looking for, or should we highlight things to point out things that are favorable to the client? How do we best communicate the case that we want to make for them? The other thing that I've really, and this has been kind of the way I've practiced for the last 15, 20 years. When I was a younger lawyer, everything was kind of a gloom and doom thing. And, like, when I talked to people about OSHA, it was always telling them, if you don't do this, this horrible thing's going to happen to you. And I realized when I was about 30, and I'll not say how old I am at this point, but we'll say 15 to 20 years ago, I kind of had a little bit of an epiphany that, look, that's not helpful to clients. What I really need to do is tell them how to work through these circumstances with these issues. And so I'm kind of constantly trying to refine, how do you help a client get through things? How do you help a client deal with things that still works with their business, and how they run their business? And so that's the thing that I'm really heavily working on, and have been working on, like I said, for 15 or 20 years. The last thing I would say is, I'm always looking for opportunities to figure out how to make the safety professionals that our clients employ more effective than they were prior to their involvement with us. And a lot of times, it can be kind of, helping the safety professionals get positioned with management. Sometimes it's a matter of helping management understand the criticality of the safety department. But that's kind of the third area that I work on a lot, in terms of kind of things that my approach has changed.
So if someone's listening, needs your help, they and you probably handle things all over the country, I'm sure.
Sure.
If they need your help, what's the best way to get in touch with you? Or if you're
Uh,
looking for a GC and they're in one of these industries that has these situations.
sure, sure. So, obviously the email address is a good way to get through to me, which is jsurma@fisherphillips.com. And then, if that doesn't work, contact me on my cell, which is 409-351-5824. Typically by text is the best way to get me there. just because a lot of times if a phone number comes in and I don't recognize it, I let it go to voicemail because I'm guessing you've had the same experience, Zane. There's a lot of folks that are calling from unknown numbers that are telling you, they've been contacted or trying to contact me about my car warranty. So, I tend not to answer calls I don't recognize, but if folks text me at that number, that's the absolute best way to get in touch with me besides my email.
Well, John, thanks so much for coming on. I really appreciate it.